Well, thank you very much for that gracious introduction, and I'd like to thank all who have played a part in making this forum available to me and available to all of us. In his great letter from a Birmingham jail, Martin Luther King Jr. said that one day the South will recognize its real heroes. I'm seeking in this talk to participate in that project of recognition because my subject is one of those real heroes. His name is Alexander Pierre Tureaud. Now, I know that that name is not unknown here. He was inducted into the Order of the Coif here at Tulane Law School the year before he passed away. There's an avenue named for him. There's a building at Louisiana State University named for Attorney Tureaud. There's a wonderful book written by Rachel Emanuel and Alexander Terreau Jr. It's called A More Noble Cause, A.P. Terreau and the Struggle for Civil Rights in Louisiana. So it's not that we're talking about somebody whose name is unknown. Many of you are going to know the name. But often it's the case that we really don't know all that much behind a name. And frankly, even for people who are familiar with Tureaud, I still think it's worthwhile devoting a lecture to him because he had such a rich career, a complicated career, a deep career. He was such an admirable person that he can stand revisiting. And so that's what I intend to do for a few minutes, revisit the career of Alexander Pierre Tureaud. He lived from 1899 to 1972. He was born in New Orleans into a large family, 12 children, Creoles of color. They lived in the 7th Ward. His father was a financially strapped house builder. His mom was a housewife. He sought all of the education that he could get here in New Orleans, and by the way, that was pretty meager. He left home when he was 17. He left home first to travel to Chicago, where he worked on the railroad for a brief period. Then he went to New York City, where he washed dishes. Then he traveled to Washington, D.C. He got a job in Washington, D.C. as a clerk in the law library of the United States Department of Justice. It was in Washington, D.C. that he actually completed high school. He went to the famous Dunbar High School at night. After he graduated from Dunbar, he went to a college for a brief period of time, but that didn't fully work out for him. His next stop was the Howard University School of Law. That's where he went to law school. He did well there. He took a course with the great Charles Hamilton Houston. It was Charles Hamilton Houston's first year at Howard University Law School, and A.P. Tureaud took a course with him. It was there that he joined the Alpha Phi Alpha fraternity. He graduated in 1925. And he actually had a nice job set up for himself in Washington, D.C., but he decided to come back to New Orleans in part to be close to his mother. So he comes back to New Orleans, and between 1926 and the early 1940s, His main job, his day job, is with the custom house. He was in charge of determining the duties to be paid on merchandise entering the port of New Orleans. That was his day job. And at night, and sort of on the margins of his life, he pursued the law. But he always wanted to pursue the law full time, but he couldn't. He had a family. His day job was at the customs house. It was not until, well, let me say a little bit more about so he comes back to New Orleans. He's working at the custom house. He starts a family. He participates in the work of the Catholic Church. He also participates in civic life, civic and social life. He was a big joiner. He was active throughout his life in various organizations. He was in the Autocrat Social and Pleasure Club. He was in the 7th Ward Civic League. He was in the Colored Knights of Pythias. He was a Knight of Peter Claver. He was in the Orleans Parish Progressive Voters League. Most importantly, he was in the NAACP. In the early 1940s, he decides that he wants to pursue the law full time. And this was a big, risky thing that he did. But he quits his job at the customs house, and in 1942, pursues the law full time. Now, between the 1940s and the time of his death, he is the leading civil rights lawyer in the state of Louisiana. There is a dissertation, a very fine dissertation, done in 1984 by Barbara Ann Worthy that tracks his life as a civil rights attorney. And in the appendix, there is a list of 90 cases that he argued on behalf of the local NAACP. 90 cases. And amongst these cases are cases, some are cases involving racial disfranchisement, cases involving segregation in schooling, jury exclusion, practically every important civil rights case in this state, Tureaud had some role in pursuing. Now, I'm not going to seek to go through the 90. And by the way, that doesn't even cover his legal practice, because throughout this entire period, he does other things. I mean, as a lawyer, he represents people in contracts actions, tort actions, probate actions, insurance cases. I mean, he does a wide range of things. But the most consequential cases, the cases that bring us here, are the cases in which he struggled with the color line. And I'm going to pick out 8, 9, 10 of those cases to give you a hint of what he was contending with. Let's start first with something that actually wasn't a law case for him. It was an investigation. In 1946, the local NAACP asked him to investigate the extrajudicial killing of John C. Jones. Jones was a black Army veteran who was arrested in Minden, Louisiana. A mob broke into the jail. Actually, a mob didn't break into the jail because the jailers actually collaborated with the mob. They took Jones out and they killed him. There was another man who escaped death by pretending to be dead. And Tureaud was sent by the NAACP to investigate this. He wrote up his notes, sent it on to the Department of Justice, and a very unusual thing happened. There was actually a prosecution. There was a prosecution of the lynchers. It was very unusual. Very unusual. Case goes to the jury. Doesn't take long for the jury to come back with an acquittal. Basically, the defense was a call for an exercise in white racial solidarity and a repudiation of these outsiders, namely the federal government, coming in and attempting to bring to justice killers. They were acquitted, but it was remarkable that there was a prosecution. That was 1946. And that gives you a sense of, I started with that for a reason. Because in the 40s and 50s, in particular, the specter of violence was pervasive. And racial terrorism was a real force. And this episode that he investigated shows that in the most vivid, the most concrete way. Let's go to some other cases. Joseph P. McElveen versus Orleans Parish School Board, 1941. Tureaud filed this case on behalf of a school teacher who simply wanted to be paid what white school teachers of his education and experience were paid. Papers were filed, investigation was done. McElveen made $1,000 a year. White school teachers of his same education level and of his same experience made $1,400 a year. Tureaud brings the case. He prevails. McElveen versus Orleans Parish School Board. As we'll see, the Orleans Parish School Board was the target of many cases brought by A.P. Terreau. Roy S. Wilson versus Board of Supervisors of LSU. Roy S. Wilson was a fellow who wanted to get a legal education. He wanted to get a legal education at the Louisiana State University. And he sued on the grounds that there was no black school that offered a substantially equal opportunity. Case was brought by A.P. Terreau, and he prevailed. He prevailed in the case of Roy S. Wilson. And this was a really big case because this begins the desegregation of higher education in this state. He wins that case. He wins a case against the medical school. He wins that case against the graduate school. The desegregation of LSU has begun right here with this case. Roy S. Wilson, 1950. This is prior to Brown versus Board of Education. I find this really interesting. We think nowadays on our side of Brown versus Board of Education, people sort of take for granted that Brown versus Board of Education was always in existence. It wasn't. For A.P. Terreau, Plessy versus Ferguson was a leading case. He tried to squeeze as much out of the formula of separate but equal as he could. He was not challenging segregation in the Wilson case. He was saying, no, I understand, separate but equal. But give us that equal. There's another case that he filed prior to Brown versus Board of Education, and in the entire corpus of cases that he filed, for me, this is the most poignant one. The name of the case, Alexander P Terreau Jr. versus Board of Supervisors of LSU. His client was his son. His client was his son. And the claim was that he was entitled to go to LSU because it was not a black school of higher education that offered the same opportunities. He fights this case before Brown versus Board of Education, and he prevails. Now, it's a very poignant thing, this case. At the hearing of this case, A.P. Terreau's wife decides to come and brings the client, their son. They're all there, in court. The lawyer representing LSU was Leander Perez, a leading white supremacist in this state. And there came a point in the hearing in which Perez turns to Alexander Pierre Terreau Jr. and says, in open court, this is not, hiding the ball. He says in open court, there sits the most ungrateful Negro in the state of Louisiana. And Mrs. Terreau talked later about how she was really so sorry that she had gone to this hearing. I'm going to come back to this. I'm going to come back to this point because later on, after I walk through some more cases, I want to think about, settle on, what must it have been like to be a lawyer under these circumstances? What amount of discipline, self-discipline, what amount of persistence, what amount of moral bravery was required to be in a courtroom representing your son under these circumstances? Let's go to another case. Annette Lovely versus Board of Supervisors, 1956. This is a continuation of the desegregation of LSU. This is a case in which black student seeks admission to LSU. Now, a number of black students have already entered LSU because of these earlier cases. Annette Lovely seeks entrance into LSU. She's denied entrance. Why? The officials at LSU say, well, you're denied entrance because the state legislature has passed a law requiring every student at LSU to have a signed affidavit from the principal of the school that the student attended and the signature from the local superintendent of education. Now, you might say to yourself, okay, it's an administrative hurdle, but what's the big deal? Well, the legislature had also passed a law saying that anybody who did anything to advance desegregation would be fired. So, Annette Lovely seeks entrance to LSU and, trying to comply with the law, sends an affidavit to her school principal. The school principal writes her and says, I think the world of you. I really hope the best for you in your career. I cannot sign this affidavit, because if I sign this affidavit, I will assuredly be fired. It's in the record. Tureaud takes that case. It's invalidated. It's struck down. But of course, in litigation, litigation doesn't happen like this. When you say something's struck down, that means you wait a while for it to be struck down. Again, get a sense of the facts give you a sense of what Tureaud was up against. Let's go to another case. Probably the biggest case in Tureaud's career. Earl Benjamin Bush versus Orleans Parish School Board. Absolutely extraordinary case. There are 3 dates that are important with respect to this case. First, September 5th, 1952. September 5th, 1952 is the day on which Tureaud files the papers. He files the Bush case. 52, this is before Brown versus Board of Education. It has an interesting relationship with Brown versus Board of Education. He files the case. The National Office of the NAACP, in the voice of Thurgood Marshall, requests that Tureaud not act on the case because there were 5 other cases in which the NAACP wanted the Supreme Court to have first bite at. Those were the cases that became Brown versus Board of Education and Bowling versus Sharp. So they said, we filed, let's see what happens with these other cases. Well, we know what happened with those other cases. Brown versus Board of Education is decided. 1956, Tureaud says, well, Brown's been decided. Of course, he requests that black students in New Orleans be permitted to go to, schools that are closest to their house regardless of racial impediment. The school authorities say no. He says, well, if you continue to say no, I'm going to have to sue you. They say, okay, fine. Or we're going to have to seek an injunction. He had sued in 52. He said, I'm going to seek relief unless you change your policies. They said, fine, proceed. So he does. He seeks injunction, and he gets one from J. Sculley Wright. That's 1956. Now again, remember, 52 he files. 56 he seeks the injunction. Nothing happens. Nothing at all happens. 1960, Judge Wright finally says, okay, enough is enough. I, on my own, am going to write up an order and say how desegregation is going to proceed. So 1960, and it's in 1960 that the 4 little girls finally breach the race line. Now, here in New Orleans, what happens around this case is absolutely extraordinary. At each and every point, the Louisiana legislature goes ballistic. If you want to see a catalog of reactions to desegregation, if you want to see just a catalog of all the different ways that desegregation could be stymied, all you need do is read the cases designated Bush versus Orleans Parish School Board. The Louisiana legislature says, okay, what we're going to do is we're going to put into the state constitution a new provision demanding racial segregation in the schools. Not having to do with race. No, not because of race, I'm quoting here, not because of race, but to, quote, promote and protect public health, morals, better education, and the peace and good order of the state. That's the reason why we want racial segregation in the schools. But it has nothing to do with race. They created a joint legislative committee to maintain segregation. They passed a whole set of laws. I would be here for an hour with the laws that they passed, but let me just mention some of them. Passed a law requiring the disregarding of certificates of graduation from people who were seeking to graduate from desegregated schools. So if you went to a desegregated school, state legislature said, fine, we're not going to recognize you as a graduate. Legislature withheld all aid, lunches, money, everything from any school that was desegregated. The legislature passed a law requiring the revocation of licenses of any teachers who taught a desegregated class. The decertification of any principal who presided over a school in which there was any desegregation. The legislature at one point criminalized any action taken toward desegregation by any federal official, including the judges. The state legislature promulgated a law that provided for the closing of any desegregated school. And the night before the four little girls actually entered the desegregated schools here, the person in charge of public schooling in Louisiana called a holiday. Judge Wright responded in a very interesting way there. He issued an order in which he listed that official, listed the governor, listed the lieutenant governor, and listed every member of the Louisiana state legislature. A pretty broad ruling. That's Bush. That case alone, frankly, would have been enough for any lawyer. But there were some other cases, and I'll go through them quickly, but again, to give you a hint of the breadth of Tureaud's actions on behalf of civil rights in this state. There was the case of the Reverend Abraham L. Davis and Dr. William R. Adams versus the mayor of New Orleans. It's a 1957 case desegregating the buses and streetcars of New Orleans. You get on I'm on a hotel on St. Charles Avenue. Trolley just runs, it's always running back and forth. You think nothing of hopping on the trolley. 1957 was not that long ago. And by the way, 1957, of course, was after Browder versus Gale, after the Montgomery bus boycott, right? You take constitutional law, you read Browder versus Gale, the litigation, you're discussing these issues in class, and, you discuss the issue, and then you turn the page and go to another subject. As if the world actually changed because of one decision. It doesn't work like that. Folks in Alabama had won, that case. Officials in New Orleans didn't pay any attention to that. Tureaud had to bring a case. Had to spend a lot of effort to uproot segregation on the buses and streetcars. Mandeville-Detege versus New Orleans City Park Improvement Association. I love to run in Audubon Park. It's beautiful. Oh, couldn't always run in Audubon Park, these parks. They excluded people of color. He brought that case, 1958. Then there's the case of John B. Garner versus Louisiana. This is an interesting one. 1961, John B. Garner was a student who participated in a sit-in. This case goes to, in fact, this was the first sit-in case to go to the Supreme Court of the United States. Garner had been convicted of trespass, disorderly conduct, something of that nature. The conviction was reversed on due process grounds. The Supreme Court said, well, there's actually no evidence that he was actually disturbing the peace or whatever it was he was charged with. There's no evidence. He was just sitting down. This case was thrown out, but that was one of the cases that A. P. Terreau involved himself in. One more. Pania versus City of New Orleans. What struck me about this is a case in which he represented the owner of a bar. Pania owned a bar and wanted to serve people regardless of race. He's in it for the money. He owns a bar. He wants to serve people who want to drink. Problem was there was a law that prohibited people from managers, owners of bars, from serving alcoholic beverages to people of different races under the same roof, unless there was a partition. Now, this was struck down, but one thing that sort of grabbed me about this, it was struck down in 1967. 1967, that's late in the Civil Rights Revolution. So these cases, I mention these cases to give you some sense of what he confronted. What does this record show? It shows many things. I'm just going to stick with two. One, it shows remarkable persistence. It's one of the things about Tureaud that's really quite extraordinary was his persistence. Stick-to-itiveness. He just hung in there. He had to hang in there to get a law practice. Very difficult for him to have a law practice. In the early 1940s, there were only a handful of black attorneys in the entire state. There were some years in which he was the only black practicing attorney in the state. Very difficult. And you can imagine why. So, you're holding yourself out to the public as an attorney. The question is, okay, well, who's going to be your client? Who's going to be your client? You're going to be appearing before white judges who are, most of them, racist. You have a jury trial. You're going to be thinking to yourself, gosh, am I going to go to a black attorney? What's a black attorney going to do for me? It was very difficult for Tureaud to convince black people to hire him. And in fact, it caused controversy. There was an early case. Tureaud was a stalwart member of the NAACP, but at one point he resigned from the New Orleans NAACP. It was a case involving disfranchisement. White registrar would simply not accept voting materials from blacks who were seeking to register to vote. Tureaud volunteers to bring the case. Local NAACP says no. Hire a white attorney. Tureaud resigns. He says, frankly, I'm a better attorney than this guy. This guy isn't committed to the case. And he wasn't. When Tureaud would get clients, he would any kind of client, he would make a point of telling black people to come watch the trial. or the hearing, whatever. Because a lot of black people, frankly, thought, they weren't used to black lawyers. They didn't really actually believe that black people could actually get up and say something in court. And he just wanted to act it out. He wanted to come watch. That was one of the biggest hurdles he had to get over. Then, of course, there was the external problem. Being a black lawyer in this period and pursuing your craft in the teeth of racism. I could go on for this in a variety of ways, but I'm just going to mention one thing that, frankly, we take for granted. His name was Alexander Pierre Terreau. But over and over and over again, people say A.P. Terreau. Well, was it A.P. Terreau simply because Alexander Pierre Terreau is sort of long? No, that wasn't it. The reason why he put initials in his name is because he did not want white people to call him by his first name. And that's what would have happened had he not done what he did. He shortened his name. And by the way, this was not idiosyncratic with him. This was done quite often. Sometimes black people would simply not give their first name. What's your name? They give their last name. So somebody had to call them by their last name. This was part of his strategy. That was part of the persistence. What else was part of the persistence? The judges. Imagine getting up in court and having to perform at a high level in front of people who you know are looking down upon you, who want you to fail, who are totally against you. I mean, imagine the self-discipline that required. Some of these judges were just out and out racist. One, E. Gordon West, Chief Judge, the Western District, Louisiana. Long career as a United States District Judge. When Brown versus Board of Education came down, Judge West wrote. He wasn't playing around. I got to give him credit. He put it on the record. He said, "I think this is one of the most regrettable decisions of all times." Thorough segregationist. And Tureaud had to go to his courtroom. And by the way, West was often overruled. But Tureaud got some, victories even from West. He had to contend with them. It's even more poignant than that. Because even some of the best judges in this period were judges who really did not think that all of us are equal. J. Sculley Wright. I clerked for J. Sculley Wright. I think that J. Sculley Wright is a wonderful person and showed himself to be a great judge. I revere J. Sculley Wright. I knew him. Wonderful man. This is what J. Sculley Wright said in an interview with a British journalist in 1960. Quote, "When I shake hands with a Negro, I have a different feeling than when I shake hands with a white." Later in the interview, he says that he did not intend to associate personally with Negroes. Now, either two things are going on here. You could take this at face value as a statement of his true beliefs, or it's possible that this was tactical. It's possible that he's here, he's a reviled character in 1960 because of Bush. It might have been that he was simply, attempting to say to his neighbors, don't think that I'm totally crazy. I don't really want to, I'm uphold federal law, but, don't think that I'm just completely unreasonable. Either way you cut it. Either way you cut it. And again, Judge Wright, a heroic figure. I mean, in 1960, Judge Wright has police protection all the time because of his judgments in the Bush case. I mention that, however, because, it's part of the story. And it showed what Tureaud had to contend with. There's a second thing about Tureaud that I want to mention, and that has to do with diplomacy. Now, you're in a law school. Your teachers expect you to master the doctrine, which is perfectly proper. You do need substantive knowledge of the doctrine, the law. You need all of that. But to be good counsel, you need more than that. You need diplomatic skills. And one thing that Tureaud had going for him, diplomatic skills. Again, the difficulty. So he has local clients, but he also has the national NAACP to contend with. And mention has been made already of Thurgood Marshall. Thurgood Marshall and Tureaud worked together. They were good friends, but they did not always see eye to eye. There were a number of cases, for instance, in which Tureaud would win a judgment, and then the question would be, what are you going to ask for a remedy? Marshall would say one thing for a remedy. Tureaud would say, I know these judges down here. I know the situation here. I know the situation with our local NAACP. I know the local, sort of tenor of opinion. I'm closer to the particular environment that's asking too much. And they would go back and forth, and Tureaud would make a judgment. He needed Marshall, he needed the national NAACP to stick with him, but he also had to be attentive to, local politics. It was a big diplomatic thing, and not only that, but then he had to deal with the white power structure. You're suing the school board. It's like even if you win, it's not like the school board goes away. So he had all these different things to contend with. And over the years, he does. Tureaud was a wonderful lawyer. He's due all of the praise that we can shower upon him. He did not prevail alone. No lawyer prevails alone. When I went through those cases, I made a point of giving the full names of the plaintiffs, of his clients. And that's perfectly proper, because those clients were collaborators with Tureaud. Without those clients, he could not have carved the great career that he carved. Those clients, each and every one, took a tremendous risk by being a client. A good number of his clients were fired from their jobs, had to leave the state, suffered intimidation. And we think, in our classes, so-and-so and so-and-so versus so-and-so and so-and-so. It's just words to us. Every one of these cases, the named client was a person who took on a tremendous burden. Now, we need to remember that. The lawyers need to remember that. That also shows something else about Tureaud, which was his inspirational quality. He inspired people to take risks. He inspired people to show the moral bravery that he showed. That's no little thing. Every lawyer needs clients. Every lawyer needs a judge willing to listen. The judges were collaborators with Tureaud as well. You know, sometimes you hear about lawyers appearing before courts, maybe the local courts or courts of appeal, or the Supreme Court. So and so and so and so won these 30 cases, as if it's a race in which there are no other participants. The fact of the matter is, Tureaud won a whole lot of cases. If he had argued those same cases 40 years before, he would not have won them. A lawyer needs a collaborator. Lawyers need judges who are willing to listen. And Tureaud got those judges. He helped persuade them, but those judges were collaborators too. J. Sculley Wright comes to mind. Judge Christenberry comes to mind. John Minor Wisdom comes to mind. Judge Tuttle. Those were his collaborators. He needed judges who were willing to listen and willing to reform the law. No lawyer does it alone. Still, recognizing that he had helped, Tureaud deserves our attention and gratitude. Now, thus far, I've focused almost entirely on his professional attainments. And I think that's proper. But it's an interesting thing. There's some people who have tremendous professional attainments who are not such nice people. That's fairly frequently the case. I mean, they're great at what they do, and they deserve applause for what they do. But they're not nice people. Tureaud appears to have been a very nice person. He seems to have been a truly wonderful man. Devoted father, devoted husband, devoted son, devoted mentor. The record is full of praise of Tureaud from other lawyers, particularly the younger cadre of black lawyers coming up after him. Devoted citizen. Those are some of the reasons why it's perfectly proper for us to laud, and why I think it would be a good thing for us to learn from Alexander Pierre Tureaud. Thank you. We have a bit of time for questions, comments, and by all means, objections. Floor is open. Yes?
As your former student, I will go first. I'm so happy to have you here. So, two questions, and hopefully these will open before people will ask more questions. But one, I'm profoundly interested in the role that being a Creole has played in African American attainment in the civil rights movement, because New Orleans is unique because we have this Black Creole population, and a lot of them have been very prominent citizens. And so I'm wondering about that. And the other thing I'm wondering about is you said he milked everything he could out of separate but equal. And focusing on equality has long been a strategy. I mean, even Derek Bell kind of had some sympathy toward we should have focused on equal and not necessarily the separate. So I was hoping maybe you could talk a little bit more about those two things, or whatever else you like.
Sure. On the first point, that's right. He was well, some people say Afro-Creole or Creole of color. So the distinction would be, Creoles, people of color whose descendants were French, Spanish. Many of them were their forebears were free people in the antebellum period. Many of them spoke French. Many of them property owners, often more. There was a real difference within the colored population. The Creoles, often different residential area, typically lighter skinned. It was that community that A.P. Terreau grew up in. He recognized early on in his career that in order for people of color, by the way, he preferred the terminology colored or Negro, and later in life he did not so much like the term black. He was not alone in that, by the way. Not alone in that at all. Thurgood Marshall, same. And here, just drop a footnote. I push this because I know people sometimes now, get really sort of persnickety on the issue of nomenclature. And as far as I'm concerned, all those terms are wholly honorable, just fine. Martin Luther King Jr. used the word Negro, so did W.E.B. Du Bois. National Association for the Advancement of Colored People. If it was good enough for Thoreau, if it was good enough for W.E.B. Du Bois, if it was good enough for Martin Luther King Jr., then it was good enough for me. African American, fine. Black, fine. Afro-American, fine. Colored for me, fine too. Negro, fine. End of footnote. Thoreau recognized that he would, and that the sort of subset of the black population of which he was a part would have to, not only would it have to, it should be capacious and march as one. And he was, and he did that. He was a light-skinned man, which caused all sorts of interesting things to happen to Thoreau. The book by Rachel Emanuel and his son begins with Thoreau on his way to a courthouse and two white lawyers, passing Thoreau and asking him the following question. Have you seen that nigger lawyer? And he, proceeds. He just disregards it. They meant it to see. They thought he was white. He had 4 sisters who left the family, basically, and passed as white. His mother, growing up, his mother would go onto streetcars, and she would go into the back of the streetcar, the colored section. And streetcars, sometimes the operator would stop and ask her to move. What they think was going on, they thought that she was a white woman, a do-gooder, who was trying to be, like a civil rights activist or something. And she would say, "No, I'm colored." And she'd have a sort of a back and forth. There were times when people would say things to Tureaud, highly racist things, thinking he was white. So this color thing, did play a role, in his life. With respect to the decisions that he made, squeezing as much equality, anytime people try to change the world's a tough place to change. The world is tough. And when you try to change the world, you often face dilemmas. And so on the question of, which way do we go? That was a real issue. Now, what happens is decisions are made, and decisions are made. Life goes on, and it's very hard then to come back and recreate the world before the decision was made. But it was a real issue. The best way to confront Jim Crow segregation. And Tureaud he was faced with various dilemmas. So here's one. The Louisiana Lawyers Association has its annual dinner. This is in the 60s. And it decides for some reason to have its annual dinner in Mississippi. Tureaud goes with some other black attorneys. They go to some meetings, seminars, people are talking about this or that. Okay? Dinner time rolls around. The black lawyers are shown to a particular place set aside for them. What do? Here it is. I mean, you can, what do? Decision has to be made. Most of the black attorneys that were with Tureaud decided to walk out. They left. And frankly, I would think, especially looking back at it in retrospect, I would think that many people, if you were just presented with these facts, I think many people today would say, you leave. And many did. He did not. He did not. Tureaud decided to go to the place set aside. He went. Now, there were some lawyers who were really mad at him. This is too conciliatory. It's a new day. You need to be more militant. And I think that's a good argument. I mean, frankly, I think, it's not like I think there was a strong argument for that's right. Leave. Strong argument. He decided not to. He had a choice. It was a dilemma. Now, as it turns out, he didn't. And his thinking was, well, we're here. I'm going to see if some good can come of this. I think with Tureaud and with a lot of people, I think, for instance, of Thurgood Marshall, we look at him. I've been talking for an hour now about Tureaud. I regard him as a hero. Does that mean that I agree with every decision that he made? No, I don't think so. I think you could, revere him. That doesn't mean I agree with every decision that he made. He has a, you have a dilemma. He took his route. Might have been sensible. You can still disagree with it. Thurgood Marshall, same thing. I think that, in fact, in the coming years, as we go through the civil rights revolution and look at the decisions that people made, we have to be much more attentive than we have been. It's not as if people didn't face dilemmas then. This past weekend, the Selma, this great Selma March. There were civil rights activists who did not participate in the events in Selma 50 years ago. There were people who had different ideas. At each and every stage, there are people who are going to have different ideas, and we need to be attentive to them. Tureaud was old school. He had a definite view of things. I think that if Tureaud came back here for an hour and, people talked and, just relaxed with him, I can guarantee you that he would say things, have beliefs that many people in this audience would not like. No. He was old school. He had very courtly manners. Tureaud did not like the sit-in movement. He did not. His idea was you get change through, you see a law, you see a policy, you challenge it in court, you get it struck down, then you walk over it. He did not like the idea of just walking and then calling the lawyers. He was deep into law abidingness. Now, frankly, I'm glad that the people who sat in abjured his counsel. I like the sit-inners. I'm glad that they just said to Thurgood Marshall and Tureaud, thank you very much, we're going to go our own way. But let's not kid ourselves about his thinking. Very much into law abidingness, very much an elitist, very much a believer in a term that is now often castigated, I think wrongly, the politics of respectability. Tureaud practiced the politics of respectability. Best foot forward. Take a look at this picture. Always immaculately dressed. Did not raise his voice. Very careful. Very self-disciplined. Now, some people, frankly, would probably sneer at him. Some people would sneer at him, Uncle Tom. That's right. Totally wrong. To have done what he did in the 1940s, the 1950s, the 1960s, there are some people in this audience who can remember what that was like. The decisions that he made, the way that he carried himself, self-denying, that's right, self-denying so that people who came after him wouldn't have to be so self-denying. Absolutely extraordinary. And I think that in the coming years, looking back, I think it'll be really important to recapture those decisions and that attitude, even if at the end of the day you disagree with it. You've been most patient. Thank you.